we put it into an LLC, it's no longer real estate, it is now an intangible asset, and that's taxed in the state of residence. So if we take that New York condo and put it in an LLC, we avoid New York State estate taxes when they die. And because it's not income generated, because it's personal use, we'll put it in a single member LLC because we don't really care about the taxation. And that way, everything flows to them individually as if they owned it in their own name for tax purposes, but for estate tax purposes, they don't own real estate in New York. And that's how we get around paying New York State, or whatever state it is, the state estate taxes in those situations.
Is the LLC considered a disregarded entity in the case of a residential rental?
Yes. In the case of a residential rental, I wouldn't use a single member LLC, because I'm concerned about the liability protection. As I said before, single-member LLCs have been disregarded by the courts for liability purposes, even though I think it's dead wrong. There's a statute in Florida that says you can have an LLC, and it doesn't say you have to have more than one member in the LLC. But courts have consistently interpreted that a single-member LLC will be set aside for asset and liability protection purposes. So we avoid that in those situations. Okay. Any other questions? Okay. I talked about this. All right. Different entities are used for different purposes. There's no one entity that's right for all situations. You always want to make sure you analyze it similarly to what we did this morning. Decide what the use of the entity is, decide what the future of the entity is, and make sure we make the right choice and do it the proper way. So that'll take us through the alphabet soup of entities. Now, normally, Greg, yes, Michael?
Recently, the local residential developers or condo developers that have commercial assets, LLCs have brought in several different corporations. I was approached by counsel, one of the client's counsel, that they were looking into doing a private annuity transaction to keep a cash flow to the owner without having it tied up if he files personal bankruptcy.
Okay.
Have you seen any of that?
All right, the question is, I guess, selling their assets to a private annuity in exchange for cash flow. Yep. It's not a simple transaction. Can it be done? Certainly. The way it's normally done is you would take the entity, sell it to we would normally do it into a trust in exchange for a private annuity, which is a contract for cash flow on a regular periodic basis back to you. In Florida, one of the protected assets that we have are annuities, and private annuities fall within that protected class of assets. You want to make sure that it is there's a sufficient cash flow to meet the payment. B, you want to make sure that it's not deemed to be a fraudulent conveyance, and that's where the big issue comes out.
He sees liability coming.
Yeah. If it was done with the intent to hinder, delay, or defraud a creditor, the whole transaction could be unwound. Okay? Now, that's not to say in certain circumstances it's not worth the effort, but you just bear that in mind that that's one of the issues that can come up. And you're going to see a whole lot more of that coming up in light of what's going on in the real estate market, on both the developer owner side and on both the speculator investor side. Yes, Mary?
Relatively easy situations. When our clients come in my office, almost always now they're opening an LLC instead of an S corp. It seems to be, kind of a new trend. Would you agree with that? Do you feel it's warranted, or is this just kind of flavor of the moment?
And let me take a step back. The question was, we see a huge trend in using LLCs instead of corporations, and what's the reason for that? The first reason that you're seeing it a lot more is Florida used to have a state income tax on the LLC and didn't have it on an S corp. So that's why, for a long period of time, you very rarely saw an LLC. That changed some years ago. I think it's about 7 or 8 years ago now, where they eliminated the, am I right, Mitch, about 7 or 8 years ago? Yeah, they eliminated the state income tax on LLCs. So then the trend was to go to the LLC route. And then you added the additional liability protection, and then 2 years ago, they revamped the whole partnership LLC statute and made us on the same par from an asset protection standpoint as Delaware and Nevada and all of the other ones. Florida has become very progressive in their partnership and LLC statute. So now, the question is, are they correct in opening the business in an LLC? My advice generally would be yes, so long as they made the election for taxes in the correct manner also. And again, if it's an operating business, we prefer to elect it as an S corporation, an LLC entity, S corporation tax status, because you avoid that Medicare tax and the self-employment issue. So that is the trend, but we think it's a good trend.
Can you avoid the Medicare tax issues with an LLP that filters down to a bunch of LLCs?
Can you avoid the Medicare tax issue with an LLP? The answer is there's a number of different ways to do that. There's actually, I've read it, it hasn't gone all the way through, but I'm even interested in trying it. There's a method to avoid it with an LLC, and the way that you do it is you set up 2 classes of membership interest. So you have your LLC, and then instead of everybody being an equal member, what you do is you set up a voting membership interest and a non-voting membership interest. So the reason the whole thing is taxed as self-employment is the argument is that you have the control and you have the operational authority in the entity, and so therefore it's self-employment. If you have, let's say you make only 10% of the membership interest voting and 90% of the membership interest non-voting, there's a very strong argument that you have that only 10% of the income should be self-employment and the other 90% is passive income, and therefore not subject to the self-employment.
And you or the clients would own portions of each of those
Well,
blocks?
sure. If the client wants to give me a portion, I'll gladly take it.
We're talking about doing it for
Yeah.
your corporation, but the clients would own portions of each one.
Exactly. Exactly. Yes.
When a member of an LLC personally signs a guarantee to the creditor, you have the same issues that arise in terms of insulating the liability that you would have in an escrow document. Is that fair to say?
Yeah, if you have someone that signs a personal guarantee, whether it's an